All right, if you're prepping for the bar exams, you know procedure is everything. It's literally the battlefield where you fight for your client. So today, we're going to build that battlefield together. We're diving deep into the foundational rules of the federal court. Think of this as your essential toolkit, the stuff you absolutely have to know for your exams and for that first time you're on your feet.
Okay, let's set the scene. You're in the federal court, you're on your feet, your opponent stands up, points to some obscure procedural rule, and says you're done. Your stomach just drops, right? But what if I told you the rules aren't a trap? What if they're actually a system with built-in escape hatches, where the end game isn't ticking boxes, but achieving justice? That's exactly what we're going to unpack.
And where are we getting all this from? We're going straight to the source, the Federal Court Rules 2011, specifically Part 1. This is the bedrock, you guys, the part you've got to know backwards and forwards.
All right, first things first. Let's get the basics locked into your memory. Rule 1.01 tells us the name, the Federal Court Rules 2011. Simple enough. Now, Rule 1.02 gives us a date you have to remember, August 1st, 2011. Why is this date so important? Well, it draws a line in the sand that can still impact cases you're working on today. And that leads us straight into how these rules actually apply.
So let's talk about Rule 1.04. This is a big one. It's all about when these rules apply. Now, Subrule 1 is easy. If your case started on or after August 1st, 2011, you're using these rules. No problem. But hang on, Subrule 2 is where you can get tripped up. For cases that started before that date, the new rules apply to any, and this is the key word, step you take after that date. And then get this, Subrule 3 gives the court a get-out-of-jail-free card. The court can say, you know what, for this particular step, let's use the old rules. This tells you something huge right from the get-go. The court loves its discretion. Okay, so that obviously begs the question, what in the world is a step in a proceeding? That's the term from Rule 1.04 Subrule 2. Well, it's definitely more than just shooting off an email to the other side. Think of it this way, it has to be a formal action that actually pushes the case forward. So, filing an application, that's a step. A letter between solicitors, no, not a step. Nailing this distinction is absolutely critical if you're ever dealing with one of those older cases that crosses that 2011 line.
Now, this whole theme of discretion, it leads us to the absolute core of Part 1. These are what I like to call the court's superpowers. They're found in Division 1.3. Seriously, if you zone out for the rest of this, just please remember these rules. They are your get-out-of-jail cards.
So first up is the big one, the court's ace in the hole. It's Rule 1.32, and it basically says the court can make any order it thinks is appropriate in the interests of justice. Think about that for a second. Any order. This is a massive, sweeping power that reminds us that the court's #1 job is to see justice done, and it has almost unlimited procedural firepower to make that happen. That's Rule 1.32.
Okay, next up we have the procedural escape hatch. Remember that opponent trying to trap you with a rule? This is your answer. Rule 1.34 says the court can dispense with compliance with, you guessed it, any rule, and it can do it before or after the deadline has passed. So if following a rule to the letter is going to create a massive injustice, the court can just say, no, we're not doing that. That's Rule 1.34. Burn it into your brain. And if you want the philosophy behind this power, look no further than this incredible quote. The relation of rules of practice to the work of justice is intended to be that of handmaid rather than mistress. What does that mean? It means the rules are here to serve justice. They're the assistant, not the boss. Justice is the boss. The rules are just tools in the toolbox, not the cage itself. That's the entire spirit of Rule 1.34, and man, is that a powerful idea to have in your back pocket when you're arguing.
And just in case you weren't convinced, here's the final power move. Rule 1.35. This one says the court can make an order that is flat out inconsistent with the rules, and the court's order wins. Every single time. The takeaway here is crystal clear. The court is the master of its own house. So you've got Rule 1.32, 1.34, and 1.35. Those are the 3 pillars of the court's ultimate authority over its own process.
Okay, so we know the court has these huge powers. That's great. But what happens when the rules are just silent? You know, you have a weird situation and there's just no rule that tells you what to do next. The path forward is completely unclear.
And trust me, this happens. You're going to face a situation one day where you're flipping through the rulebook and there's just nothing. You're not sure what the right procedure is. So what do? Just wing it and hope the judge doesn't notice? No way. Thankfully, there's a rule for when there is no rule. It's Rule 1.21.
And it says that if the procedure isn't laid out, or if you're just not sure, you apply to the court for directions. You basically go to the judge and say, hey, we're not sure how to do this, can you tell us? It's a fantastic tool that lets the court create a procedure on the fly to keep things moving. So when you're lost in the woods, remember your compass. Rule 1.21.
All right, let's switch gears to something that sounds super simple, but I promise you, trips up even senior lawyers. Calculating time. Getting this wrong is not a small mistake. It can be absolutely catastrophic. You can miss a filing deadline and torpedo your whole case. The rules have a very, very specific way of doing this.
Okay, let's walk through Rule 1.61 step by step. First, Subrule 2. You always exclude the day the thing happens, so the clock starts tomorrow. Got it? Good. Second, Subrule 3. And this is a classic trap. If you have a deadline that's 5 days or less, you don't count weekends or public holidays. That can save your skin. Third, Subrule 4 is the next business day rule. If your deadline falls on a Saturday or a holiday, it just rolls over to the next day the court is open. Pew! And finally, the big one, Subrule 5. Remember, the court basically shuts down over Christmas. From December 24th to January 14th, the clock is paused. You have to know these 4 steps inside and out. Again, that's all in Rule 1.61.
So, we've looked at how the rules apply, we've seen the court's incredible superpowers, and we've even covered the nitty-gritty of counting days. Now, let's tie it all together with the one golden rule that governs everything else.
This is it. This quote from the High Court in Queensland v. JL Holdings. This should be your North Star. Justice is the paramount consideration. Every single rule we just talked about, every power, every procedure, it all serves this one single idea. The rules work for justice. It's not the other way around.
And if you ever need proof, you've got it. Just think back to those superpower rules we talked about. Rule 1.32, the power to make any order for justice, and Rule 1.34, the power to just ignore a rule if it gets in the way of justice. These aren't footnotes, they're the heart of the system. They prove that at the end of the day, justice beats a technicality. Every time.
So as you're studying for your exams, I want to leave you with a question. Now that you know the court can literally bend, break, or even create new rules all in the name of justice, how does that change how you're going to argue a point? It means you're not just a rulebook lawyer, it means you argue the fairness, the equity, the justice of your client's position. And that is how you go from being a lawyer to being a true advocate in the federal court.